Rafael. How are you doing?
I am doing great, Yvonne. How about you?
I'm doing good. My head feels like it might be a bit expanded from it was about 45 minutes ago.
And why is that, Yvonne?
Well, we just finished a great interview with John Cattie.
We did. It was awesome. It really was. Great topic. But as you're hinting, it's complicated and it's messy and it really is. You asked a couple of great questions in there. Why does it have to be so complicated? And we're hoping that this conversation really goes further into explaining that.
I hope so too. I just almost every time we get into a conversation about Medicare set-asides, liens, or anything like that, I feel like I've landed in the deep end of something. I don't know what, but not a place I really want to be, because it feels so foreign, I guess, is the thing.
Yeah. Yeah. I think you and the rest of the industry feel that way. That's why folks don't talk about it. That's why folks push it away, because it really is. It's so incredibly difficult, I think, to grasp not only your state workers' comp law, but all these federal things that are happening in and around it.
Yeah, it is something. So we're having a really great conversation with John Cattie of Cattie and Gonzalez. So let's get to it. Shall we, Ralph?
Let's do it.
Well, I'm so happy that we have John Cattie with us today. Hello, John.
Hello, Yvonne. Hi, Rafael. How are we doing today?
I'm doing great. How is it up in your neck of the woods?
Oh, it's sunny but chilly. About 45 degrees today. We've gone between 80 and 45 here for the past few days. But all told, it is February, so all to be expected. Beautiful day outside.
Awesome. Yeah, I know. When it gets below 70 in Tampa, man, things are not right.
Well, we're not in the Northeast. It's got 2 feet of snow on the ground.
I know. I've been getting pictures all day on my family chat and stuff. All right. So again, thanks for joining us today and spending some time. I cannot believe it's season 6, and this is the first time we have you on our podcast.
Well, I mean, I can, because this is just how long it takes for us to get around to the fun stuff that I do when I plug into the workers' comp world.
All right. Well, welcome. So for those folks that might not know you, please take just a minute or two to briefly introduce yourself, what you do, what you've been doing, basically what you've been up to in the work comp world.
Yeah. So my name is John Cattie. I'm the managing partner of the law firm of Cattie and Gonzalez. And we focus on Medicare Secondary Payer compliance. So all those Medicare set-asides, the MSAs that folks hate to have to deal with and talk about, but also the mandatory reporting that folks have to do to Medicare, the verification of Medicare liens and repayment of those for workers' comp, and also some other non-Medicare lien work that we do that probably needs to become more on top of mind for the work comp industry. And it's a goal of mine for this year to start to shed some light on that for folks.
So before we get going, because y'all both know this is not my area of expertise, so I'm gonna turn it over to Rafael, but I'm gonna poke and ask a couple of questions first. So for folks that are not super experienced in this area, so the world of Medicare set-asides, Medicare secondary compliance, all those things you just mentioned, why are these things important for folks in workers' compensation that don't necessarily work in this part of the ecosystem?
Yep. Great question. So if you're working on a claim involving a Medicare beneficiary, if it's not done right, if you're not doing certain things at certain points of time during the life of the claim, you are exposing yourself, your organization, the claimant to fines, penalties, and or denial of benefits from Medicare. And depending on where you are in the claim, the type of exposure that you have can be significant if you're not paying attention to what you're supposed to be doing at that point in time.
Awesome. So you had mentioned, so for folks that don't know this, so like when we set up our podcast guests, we have a little questionnaire that we ask the guests to fill out and ask them what they'd like to talk about. So John, you said that you wanted to focus on non-Medicare lien exposure.
I do, Yvonne. I do, because from my perspective, as someone who plugs into the workers' comp world from a certain angle, so to speak, all for 20 years now, folks have been concerned about set-asides and MSAs, right? It's gotten all the oxygen in the room, the brightest of spotlights at every single conference around the country now. And more recently, you've heard a lot more people talking about the mandatory Medicare reporting. You're starting to hear more about Medicare conditional payments for past liens that Medicare may have. So all that Medicare discussion gets all the attention. But what a lot of folks in the workers' comp industry don't realize, probably because there hasn't been enough discussion about it, is that there are certain exposures that exist for non-Medicare lien obligations, meaning if you've got a claimant who is not necessarily on Medicare, but for example, on state Medicaid, as one example, if that Medicaid lien is not getting handled and reimbursed appropriately, well, there's exposure there to not only the claimant, but to the payer of the claim, potentially, for failure to repay that Medicaid lien. The same is true for other federal lines of insurance, such as claimants who may be veterans and treat at the VA, or who have TRICARE insurance for their family or their spouse. Those are all other types of health insurance at the federal level, same as Medicare is, but there's exposure to payers of claims with respect to those lines of insurance that don't get nearly the attention that Medicare does.
Understood. Ralph, your turn.
Thank you, ma'am. John, this may never happen again. She's turned it over to me with more than 2 minutes left. This is a win, John. This is a win.
We take them when we can get them, right?
Finally, I get a word or two.
Let me give you a little caveat. Remember, Ralph, we want to be talking to John for those folks that don't know about this world. So remember to keep your teacher questions in line.
Yes, ma'am. Absolutely. So, John, let's go down that road. You've mentioned several of these other federal agencies and federal programs, and it sounded like you were talking about that they have the same rights of reimbursement, meaning if Medicaid made a payment related to that workers' comp injury, you're telling me that Medicaid has a right of reimbursement from the plaintiff, the defense, from both sides of the fence?
Yeah, so specific to Medicaid, Rafael, from both sides of both sides of the fence. Medicaid has a right to seek reimbursement under their state-specific third-party lien recovery statutes for any payments made from date of loss through date of settlement, judgment, or award on behalf of that Medicaid claimant and beneficiary. Again, Medicaid is different than Medicare, two separate lines of health insurance that someone gets qualified for in different kinds of ways. And a lot of folks will, throw Medicare and Medicaid together for a number of different reasons. But at the end of the day, two separate lines of federal health insurance, two different potential lien obligations, but both of these have the same level of exposure if the lien for past medicals is not getting reimbursed appropriately.
John, can an individual receive both Medicare and Medicaid at the same time while that workers' comp case still going on?
Yeah, absolutely. Absolutely, Rafi. Yeah, sure can. Qualification for Medicare is entitlement based, meaning you've paid into the system long enough through your biweekly paychecks to qualify for Medicare coverage when the time is right. Typically age 65 or older, or if you suffer a disabling event and you apply for and are accepted for Social Security, disability income, or SSDI benefits. Medicaid, on the other hand, is financial, so means related, income, asset, and resource testing, right? So generally speaking, varies from state to state, but for a single individual, qualification for that program is somewhere at or around $2,000 per month, right? So you have these people who qualify for Medicare coverage because of their work history or their age, but also lack the sufficient financial means and qualify for Medicaid coverage as well. So you do have individuals who have both Medicare and Medicaid coverage at the very same time.
And both of these systems would have a right of reimbursement for any payments that they may have made that are related to the comp injury?
Yeah, absolutely right. Absolutely right. And depending on the bill, depending on the treatment, depending on the body part, condition, or medical expense in question, it might be something that Medicare would have picked up. But there are exceptions to Medicare coverage, which then means Medicaid would pick it up if not covered by Medicare.
Sounds very complicated, John. But in addition to that right there, if I think about it a little longer, 50 different states with 50 different Medicaid laws. Is that also accurate?
Yep, that's right. The Medicaid laws, unlike Medicare, which we've got one law at the federal level that dictates all things Medicare related for set-asides and liens and reporting and things like that. Medicaid lien reimbursement is state specific. So 50 individual states, 50 different laws that someone has to be aware of and what those rights look like.
Wow. I think you mentioned Medicare, Medicaid. You also mentioned VA and TRICARE benefits. Help folks understand, what are we talking about there?
Yep. So there we're talking about military liens that may come into play. So when you've got a claimant who served in the armed forces at some point in time, and is treating medically for their comp claim at their local VA facility, the Veterans Affairs. There is a federal law, the Federal Medical Care Recovery Act, that says that the U.S. government's got a right to be paid back, and we can go seek recovery of our past payments that were made by the VA or under the TRICARE program from the injured individual or from third-party payers. So again, another federal line of insurance, in fact, two that fall under this one statute where there's exposure on both sides of the V for failure to repay the VA lien on the one hand or a TRICARE lien on the other hand.
So John, you mentioned VA, meaning the individual is a veteran of the armed forces. So he would be eligible or she would be eligible as a veteran. But TRICARE, I think earlier you mentioned they could be family members of a currently serving military individual. Is that right?
That's correct. So we're talking about spouses, we're talking about children. So it extends out from the actual service member themselves.
So I'm thinking through that this, for example, with a child, a minor, who gets involved, heaven forbid, in a bad auto accident, and the military ends up making that payment. What you're saying is that through the TRICARE system, who is making the payment, but then if there are third party from that lawsuit proceeds, that the TRICARE system would be entitled to reimbursement either from the plaintiff or the insurance carrier, for example, who may have paid that settlement. Is that right?
Exactly right. Just in the same kind of way as we think about it in the Medicare world, that everyone is a lot more familiar with who's watching this today. The same right to pursue basically anybody who makes or receives a payment of a claim. The same is true for TRICARE insurance in that scenario, for VA, and for Medicaid.
John, makes me think about, all right, we've covered Medicare, Medicaid, military. Perhaps the largest part of insurance out there are group health insurance carriers. You know, they probably insure 150, 170 million folks, right, that get their insurance from their employer. Am I swimming in the right ocean there? Are those plans also entitled to reimbursement?
Potentially they are, Rafael. Potentially they are. Now, those are more akin to private health insurance plans as opposed to federal governmental health insurance plans. So there you have to start thinking about, okay, what is in the what's in the member agreement that healthcare provider for that plan member. What rights of recovery are dictated within those documents. Some plans will allow for recovery only against that individual or others who are directly covered by that plan. Others write their plans a little more broadly and allow for the plan to recover not only from the injured individual or others who are covered under that plan, but also from payers of claims in satisfaction of liability or workers' comp claims that are being resolved on behalf of that plan member. So important to be aware of these other possibilities outside of the Medicare world. Medicare's gotten all the attention for 20 plus years now, which is great because I feel like we've got a fairly educated workers' comp industry now when it comes to Medicare, at least with regards to, hey, I know I've got to worry about MSAs and Medicare mandatory reporting and conditional payments, but that's not the end of the story when it comes to healthcare lien obligations and exposure to folks who have been paying medicals on behalf of that claimant.
All right, Yvonne, I know you're dying over there. I know you've got a zillion questions. Come on, let's have them.
I don't know about a zillion, but my brain, as I mentioned earlier, it always goes to the folks that are maybe not as experienced in the system. They're just coming into the industry, kind of getting their sea legs, if you know what I mean, in the workers' comp space. So we already have talked on this podcast about adjusters in particular having to keep track of so much information. You guys were just talking about how, I believe it was Medicaid, having 50 different sets of laws and having to keep track of all that depending on where you're adjusting claims, right? So adjusters have to stay on top of all of this, like all these liens and non-Medicare liens and Medicare liens. They have to understand all this stuff that you guys talk about all the time. Is that true?
Understand it. They need to be able to issue spot. I think they need to be able to ask the right questions at the start of the claim in terms of, hey, what other health insurance do you have? Right? Asking them for, hey, are you on Medicaid? Or did you serve in the military? Do you have insurance other than Medicare? What states have you lived in since you got hurt? Things like that, which are going to dredge up potential exposures that they then, based on internal protocols, know how to handle. It's impossible for them to expect folks at the desk level to stay on top of all 50 state Medicaid statutes, depending on where they're assigned claims.
Right. Well, I mean, they're going to stay on top of the states where they're adjusting claims. So I understand that. But I mean, it really taxes my brain to think about all the different things that an adjuster has to keep track of, has to be. So help me understand. I kind of almost want Rafael to kind of present a case scenario and have you guys walk through it in terms of how you start to, because you mentioned it, John, as an exposure. So help me understand what that means. So what we're looking for is if a claim has happened, if there are other exposures, and I want to understand more about that and what that means.
Yep. So let's talk about this first in the context of Medicare, because I think that's going to be a nice transition to where we're going with this. So when we have a claim involving a Medicare beneficiary, depending on whether it's accepted or denied, there are certain activities that need to happen on that file. If it's an accepted claim, we know we have to report ORM, ongoing responsibility medical to Medicare. We know we have to check with Medicare about, hey, have you made any conditional payments for these specific body parts that we're accepting responsibility for? Hey, we know we need to go out and get an MSA if we're going to want to resolve this full and final at some point in time down the road. And we know there's a certain time, certain rhythm to all of that. And then finally, once the claim is resolved, we know we have to report certain data back to Medicare in the form of that post-settlement TPOC report, right? Total payment obligation to the claimant. Okay? So there's certain reporting that has to get done. There's certain reimbursement steps that have to get done when it comes to Medicare. When it comes to Medicaid, for example, it's not apples to apples necessarily, because there's no MSA requirement when it comes to Medicaid, right? What happens is that if a claimant who is on Medicaid receives too much money without taking certain steps, they're going to be disqualified from their Medicaid coverage. Just like that. Irregardless of going out to a vendor and getting an MSA done or asking Medicare to review and approve an MSA, none of that exists in the Medicaid world. It is if you receive too much money and Medicaid's checking, and they check every month, then you will not be able to use your Medicaid benefits. In terms of the lien for past medicals from date of loss through date of settlement, judgment, or award, if the state Medicaid program is not getting paid back and no one's talking to them about this, they've got a right of recovery against the Medicaid beneficiary, the attorney representing if represented, or third-party payers on the claims. Same is true for the other federal programs that we talked about, for VA and TRICARE, when it comes to these repayment obligations that happen. Mm-hmm. Okay?
So walk us through an example. I kind of want to walk through an example of a person that was had served in the military before. How does that shake out?
Yep, can do. So let's say we've got an active military member. All right, hurt on the job within the scope, and it is, let's say it's denied in full by his employer. Okay, he is treating at the VA for his injuries because as a service member, he has the right to do that. Mm-hmm. So he's treating at the VA. The VA is running up a bill for treatment. Let's get around to resolving the workers' comp claim, fully denied, final settlement, close it out, right? The VA may assert a lien for medicals paid on his behalf from date of loss through date of settlement. And if no one's checking with the VA, there's a right of recovery there that exists against that claimant or against the payer of the workers' compensation claim.
So, but if it was denied, okay, this is where I feel like I don't know anything about anything when it comes to workers' comp, because I'm like, what did you just say? So if it was denied, as you said, so who owes the money? The claimant owes the money back? Is that what you said?
The federal law allows the agency, Yvonne, to pursue recovery from anybody on that claim. They have a right to pursue the claimant for recovery of their lien, but they also have a right to pursue their lien from third-party payers. Now, can they do that successfully? That's a different question, right? And I think your head is going to, it's fully denied, got settled on that basis. We're done and out the door. We don't owe it to anybody. But I will tell you that in and of itself does not necessarily defeat the VA's lien assertion.
Yvonne, it's not just you. A lot of folks around the country get confused by that. Denied workers' comp case, an employer or carrier has not paid a dime in indemnity benefits or in medical benefits. But then they settle that case with the plaintiff, right? With the injured worker. Now that settlement has taken place, now that funds have been paid, now it's when that VA system comes out and says, wait a minute, I ended up paying for that medical because workers' comp denied it. I'm entitled to reimbursement of those medical expenses, either from you, the plaintiff, because you now have a settlement as a result of the case, or maybe from that employer carrier who originally denied the claim, but has now made payment of that settlement, right?
Understood. Yeah. Now I understand, I think. Good grief.
Yeah. It gets complicated, doesn't it, John?
Complicated.
It does. And there's probably a reason why no one's really talked about this non-Medicare lien exposure for all this period of time, is because Medicare is complicated enough for everybody, right? Like it's taken us 20 years to kind of get our head around the fact that Medicare is a lot more than just MSAs and set-asides.
Well, I was going to say, I mean, I always kind of measure things, if you will, against the kind of things that you see talked about at the conferences that we attend, right? And I do realize there are a few events that are only about Medicare set-asides. And I've been to a couple of them, believe it or not.
And you survived. Look at you.
I survived. I survived. But, you know, when you go to a general workers' compensation event, you know, Medicare or non-Medicare liens, I don't know that I've ever seen non-Medicare liens on the docket. We're going to be doing a webinar here real soon, so we'll be talking about it. But the amount of space devoted to these topics seems to be not that much compared to all the other things that we talk about. So it makes me scratch my head going, boy, these things seem really complicated in a lot of different ways. And so why aren't we talking about them more?
We're not talking about it because not many people are aware of it. You're not having the federal government announcing with a big megaphone, hey, we've got these lien recovery rights under these statutes, and workers' comp, you need to be worried about all of these when you're resolving a claim.
Mm-hmm.
We just don't have that. What we've had in workers' comp now for a long time is a very active, aggressive Medicare compliance industry who is pushing MSAs and all things Medicare to the top of the brain, so that at every conference we go to, there's some sort of Medicare discussion, whether it's about set-asides, reporting, or conditional payments. And that's been the topic du jour. And that's enough to make all our brains hurt when it's all said and done.
Well, my brain hurts. My brain hurts.
Like, that's enough. The reality is that just because people aren't talking about it, just because the federal government's not making announcements to us as an industry, doesn't change what the law says, doesn't change the ability for the agency to do X, Y, and Z. And doesn't mean that's not happening today. When it's all said and done.
That was going to be my question, right? So we know with Medicare, there's an industry talking about it. The drum, beat goes on and on and on every day. In these other areas, we're not seeing the federal government beat the drum. But nonetheless, what I think you're telling us is Medicaid is, in fact, coming after folks for reimbursement of those liens. VA and TRICARE and the group health carriers, all of those entities are doing exactly the same thing. We're just not hearing it because there's no industry there to bombard us with that information. Is that what I think you said?
Let's be perfectly honest about it. The industry amplifies the concerns.
Yeah.
Right? And it is the messenger for the entire work comp industry. That's how it was, starting with the Patel memo back in 2001 when we're talking Medicare, right? And everything that followed after that. It was the Medicare compliance industry, the MSA industry, that brought that to workers' comp. Before then, no one knew about any of that stuff, even though the law had existed at that point for many, many years. And in fact, if we're talking about from comp, that law was on the books for almost 40 years before that Patel memo, as far as Medicare being a secondary payer to workers' comp, right? Since 1965. But it took that Patel memo from the government and an MSA industry to amplify that message to the workers' comp industry at large about what's going on. The fact is that Medicaid, VA, TRICARE, they're all in the same position as Medicare was pre-Patel memo. People just aren't talking about it because they haven't been talking about it.
I'm going to ask, everybody that knows me is going to laugh out loud when I say this, but I'm going to say it anyway. But it just occurs to me. So one of the reasons that I started this podcast with Rafael is, number one, he asked me to and encouraged me to. But number two, when I started out in the workers' compensation industry, it was, wasn't by choice. It was sort of an accident, which I hate to admit, but it was. But I've stayed because I found it to be a really great industry. And that's what we're doing here, is trying to encourage folks to find a place here. But what has always struck me, literally more like hit me between the eyes, is that I get that it's complicated. There are other complicated industries, but it seems like we go out of our way to maintain complexity. Like, why don't we do a better job of sort of sorting out the details? At least, I'm always thinking about, for example, on the behalf of a claims professional. I'm not a claims professional, but I imagine it must be quite difficult for them to sort through and keep track of all this stuff. But am I missing something? Like, why does it have to be so hard?
I think it's like any other industry. To do it well requires and demands expertise and experience in those areas. It's a very layered role. And to be able to be a claims professional who is a successful claims professional really requires focus, requires understanding, requires knowledge in all these different facets and these layers that come across their desk every day.
Yeah.
I mean, listen, Yvonne, I haven't been doing this stuff my whole career. Okay. I didn't go to law school to be a lien resolution attorney or Medicare compliance attorney. There was no class for that back in my days at Villanova. Heck, I came out of school and I was a corporate attorney doing mergers and acquisitions work.
Well, I was going to ask you,
law firm.
I should have started out with this line of questioning, but I'm going to go there now. So say that again. You started out as what kind of attorney?
I started out as a corporate attorney doing mergers and acquisitions work for buy-side clients for a large Southeast regional law firm. And I did that for a couple years, and that was as exciting as you can imagine that it was. But I was downsized in 2008 during the Great Recession, right? I was one of thousands of people, right? And at that point in time, living with a couple fraternity brothers of mine from UNC, from North Carolina, and one of them was always working at his computer on these multiple monitors. Now, this is back in 2008, where you probably didn't see this every day. Mm-hmm. Multiple monitors with big Excel spreadsheets. And I finally said, hey, listen, Ryan, what are you doing here? What is this all about? And he said, well, so I work for a company. My job is to resolve 60,000 Medicare and Medicaid liens for the Vioxx MDL.
Oh, my goodness.
For that mass tort. So he was working for a company called Garrettson Resolution Group. He said, hey, listen, these guys are actually starting up a new business group. I don't know what this means, but they call it MSA. And I said, I don't know what MSA means either, but I need a job. Can you get me an interview? And had a good interview with them. And they were looking for someone like me to come in who had a legal background, an entrepreneurial itch, and wanted to build out their set-aside group from the ground up. So I got in there in 2008, and that's how all this started for me in this kind of world. I had no training in law school about this stuff. It was not a dream of mine to resolve liens or to share the bad news about up to $1,000 per day penalties for mandatory Medicare reporting noncompliance, or to share the news today that, hey, you've got a whole lot more exposure for non-Medicare liens that you might not be aware of right now. But this is the profession that I've fallen into. I've been lucky and blessed to be in the position I am, to have so many clients trust me with their concerns about this stuff all over the country, and to be able to focus my legal practice on these specific issues. Because as I continue to have conversations with folks around the country, the issues that we work every day, day in and day out, are issues that nobody else wants to be within 1,000 feet of. And like I've said to others in the past, somebody's got to do it. Somebody's got to take care of these dirty, yucky issues and handle these for people so that they can continue moving forward, whether we're talking about it from the claimant's perspective or from the employer's perspective.
Mm-hmm. Well, God bless both of you, because I know I wouldn't want to be within 10,000. What did you say? 10,000 feet, 1,000 feet? The closest that I do get to it gives me the heebie-jeebies. Woo!
Yvonne, it never fails that whenever either Rafael or I are talking at conferences in person, that usually it's at least the first 3 rows, but certainly the first row, nobody sits there. And because they don't want to be too close to all the Medicare compliance talk that's going on.
Well, yes, that might be true, but I have also witnessed myself firsthand that I have never seen any one topic get so many questions and answers after the topic is over. Like when the session is done, there is a line of people, and I've seen it every time. And I joke with Rafael about this, because it's like, so clearly this is the thing. There's a need for what you all do, because people don't understand it, and they depend on people like you to know it and help them sort it all out. So thank goodness for you guys.
It's a full-time job,
Clearly.
and that's part of the reason why it's impossible to expect a claims professional to be able to stay on top of all this stuff. It's Medicare or non-Medicare, right? It really is too much as an expectation on them to be able to handle effectively and compliantly themselves.
Well, I didn't think I was going to have that many questions. Ralph, were there any other questions you would like to ask John?
No, you did fantastic. I think we're going to have to start calling you MSP Queen of the Universe here pretty soon.
John, he tries to do that to me at conferences, and I'm like, nope, he's your man. Go talk to him.
Well, he's using the wrong term, Yvonne, because if he were to call you the lien queen, that might have a better ring.
I like it. John. See, I'm going to write that down. The lien
There can
queen.
be a sash. There can be a little crown. A scepter, maybe?
No.
It's going to happen. Ladies and gentlemen, you heard it here. Cattie has found it. John Cattie found it. A sash. The lien queen, ladies and gentlemen. There she is. Oh, there she is.
Okay, all right. Boy, we're going from bad to worse. All right. John.
Oh, I am loving this. This is the best ever.
So, John, was there anything else that you wanted to talk about that we didn't ask you about?
I think the only other message that I wanted to share with everybody today who's watching is that there's always help around the corner. If you're willing to ask for help and to seek it out, okay? Don't ever feel like these issues are so overwhelming. The penalties seem like there's so much to have to keep track of. How in the world am I going to be able to know when to do things where? Your point's a great one. It's not just when Rafael and I talk about this stuff at conferences. Anybody that's in the Medicare compliance space, they always have a line after the discussion, because everybody's got questions about this stuff. It's okay to raise your hand and ask for help. That's what folks in the Medicare compliance industry, that's what we're here for and here to help out with, and because it takes a village to keep everybody straight when it comes to this stuff, to paraphrase that adage.
Well, thank you. And so there's always something else we like to talk about on our episodes, and that is we'd like to know what it is that you do for fun, John. So when you're not doing Medicare set-asides or non-Medicare lien shenanigans, what are you doing? How do you spend your time?
Oh, Yvonne, in an alternate life, in that big, vast multiverse, I am the GM of an NFL football team. So I love fantasy football. And I'm so bummed now because the season's just getting done a month or so ago, and I've got to wait for the off season. But when that cranks up during the summertime, that is such a great diversion that I thoroughly enjoy working on and having fun with my friends and colleagues to do all of that. And in between now and then, I try to get out and play a little golf now and again. I'm not very good at that, but I have fun doing it. Love traveling, love getting out with my wife, Stephanie, and getting around. trying out new restaurants here in the Charlotte area or wherever we're traveling to. So there's a whole other side to the John Cattie that the industry sees as compared to the downtime.
Awesome. Those all sound like a lot of fun, except for the fantasy football. Not for me, but I know lots of people that are into it.
Sports have always been a passion of mine. You can tell from the wall behind me.
Yeah. I was going to ask you to like point out some of those things. I see a couple basketball pictures.
Yep. So the picture's over this shoulder right here. On bottom, that's Michael Jordan hitting the game-winning shot in the 1982 NCAA National Championship game.
Mm-hmm.
Above him is Chris Jenkins from Villanova hitting the game-winning basket against North Carolina in the 2016 National Championship game. Those are my two schools. I went to North Carolina for undergrad, went to Villanova for grad school. So I've got both of those.
Awesome.
The soccer picture right behind me hung in my room as a kid. That's Kevin Keegan. He used to captain the England national team back in the 70s. A painting by a famous sports painter, Leroy Neiman. Over my other shoulder are 4 pieces of sports memorabilia, signed pictures by Joe DiMaggio, Ted Williams, Hank Aaron, Pete Rose, all stuff that was gifted to me from my dad.
Aw, baseball.
Yeah.
Awesome.
Yep. That's right. And there's, the other walls of the office have got other scenes as well. And if I'm ever invited on to this podcast ever again to share more bad news with everybody about their lien exposure, maybe I'll point the camera at another wall and share some more with you.
Awesome. Well, I actually got to meet Pete Rose in person at one of the national comp conferences. So that was a highlight. And I bought a signed picture of him for my husband. So
excellent. Is he a Pete Rose fan?
He is.
Yeah.
And I'm blanking on the other guy that we had come to Comp Loudy, and I can't think of it. But that was a picture. It was Pete Rose and a guy that was with the Padres at the time. Blanking on his name.
Tony Gwynn, maybe.
No. I'll have to go find it and put it in the notes because I'm embarrassed that I can't think of it. And if Kristen hears this, she's going to laugh. All right. Well, thank you so much for joining us. It was a pleasure. I learned some things, which is always a good thing.
Well, thank you, guys. Appreciate the invitation. Had a lot of fun talking with you guys today, and I'll see you around.
Thanks. Hope to see you soon. Hasta luego.
Hasta luego.